Schwarzenegger versus EMA, which is scheduled for oral argument before the Supreme Court, is a case about whether or not the state can constitutionally regulate the sale of violent video games to minors. And I think at the start it's worth saying that easy cases generally don't get to the Supreme Court, and so there are going to be two views on a lot of what I'll say about the case, and that's fine. Although one thing that is very interesting about this case is that most courts have decided that the regulations of sale of violent video games to minors are unconstitutional. And this is unusual for the Supreme Court to take up a case like this because there's generally consensus among lower courts. And that raises the specter that the Supreme Court may be reviewing the standard under which it considers such cases. And that's something to watch out for. So the basic case is California wanted to pass a statute saying that it would impose a penalty of $1,000 each time a vendor sold a violent video game to a minor, and it wanted vendors to label violent video games with a sticker that said 18 on it, indicating that the video game would only be sold to people who were 18 or older. And what's now the Entertainment Merchants Association brought a facial challenge to that law, saying a couple of things. First of all, that the statute was in violation of the First Amendment of the United States Constitution because it regulated expressive content and access to expressive content by the minors. And second of all, it argued that the statute was unconstitutionally vague. This had to do because it's a video game statute, the statute barred for example, the heinous killing of a human image. Well, the problem here is what's a human image? When you're talking about video games, is a big blob on the screen from Mario Brothers a human image or not? Right? That becomes quite hard to define. And so there was an argument that the statute was unconstitutionally vague. Both the District Court and Court of Appeals held that under the First Amendment, if the state attempts to regulate the content of speech, it must do so under a test called strict scrutiny, of which all lawyers are famously aware. The idea being that the state has to have both a compelling state interest and the law that it uses to advance that compelling state interest must be narrowly tailored and must not reach any more speech than is necessary in order to achieve the state's interest. Although the district court below said that the state did have a compelling state interest in protecting minors from psychological harm, the Court of Appeals said no, not so much, that the attempt to prevent minors from thinking bad thoughts is thought control, and that's not a legitimate state interest. Both the District Court and the Court of Appeals did say, however, that the statute was not sufficiently narrowly drawn to satisfy the state interest. And both the District Court and the Court of Appeals expressed serious concerns about the social science research that was being used by the state of California. Because that research didn't show that violent video games cause children to become aggressive, it could have just as easily shown that aggressive children like to play violent video games. So that's the posture that comes to the court. There's a lot there to talk about in terms of First Amendment law. Because I'm a video game scholar, I think I'd like to take a bit of a different tack on it, which is, one, the very fact that I, a video game scholar, would be asked to speak on this topic shows that there's something going on here that we ought to be very nervous about. And that is the idea that video games are somehow exceptional, that there's something new here. And I think we need to be very nervous about that. Every new form of medium has come under similar scrutiny for corrupting the youth, right? We go all the way back to Socrates and the idea that his philosophical innovations are somehow corrupting the youth. And we've seen this again and again, from novels to theater, right, to plays, and something more recent, of course, comic books, right, and television and movies. Each one has had this new accusation, this accusation leveled at it that it's somehow new and has this unique impact on the youth. And we're seeing this again in California's argument. It's saying that video games, because they're interactive, have this sort of unique potential to impact children. Of course, that's just proof of the expressive value of video games, right? Good literature is interactive. The idea when you're reading a really good book is that you live the story. The fact that video games are good at this means that they are especially subject to First Amendment protection as expressive works. There's no serious question, and the state of California, of course, can't really say with a straight face that the First Amendment doesn't apply, but they do continue to make these claims of exceptionalism, that video games are new, that they're different, that the harm here is somehow something that ought to make the Supreme Court adopt a different rule for video games than it has adopted for any other means of expression. I think that's worth pointing out at the outset. The second thing is, and this is barely hinted at in the opinions and in the briefs of the parties, but I think it has a bigger impact than we might think, is that the law doesn't seem to have a real grip on the realities of video game creation, manufacture, and distribution. For one thing, the idea that a vendor would be responsible for the content of a video game, that's kind of the Hollywood view of video games, right? That a manufacturer would make a video game and therefore must label the video game based on what's in it. That's not how a lot of video games are being made today. We talk a lot about user-generated content in the industry. The idea being that the video game manufacturer creates a framework, a set of tools. For example, an example here would be the recently released game Little Big Planet, right? In which the players generate a lot of the content. Now, how in the world is the vendor going to be able to label the content of a video game if the vendor isn't making the content of the video game? People are. And unsurprisingly, right, a lot of the speech that goes on through video games that we get quite nervous about comes from other players of the game. Whether they make the violent content, whether they make sexual content, this is the same deal. The problem is that the game manufacturer can't control what's called the content of the game in the statute. And so making vendors liable for $1,000 a pop if somebody else makes some modification of the game, I think there really raises some problems with the statute. Okay. A similar issue, and one that only is touched on in the briefs of the parties, is that the statute relies on an antiquated and soon-to-be defunct method of distribution of video games. The idea that you would get your video games by getting into a car and driving down to the store and buying it over the counter from some retailer, and therefore you'd have this sort of chance to see the label on the package, is something that I think won't last very much longer. We do direct-to-download now. Even for consoles, people have things like the Live Marketplace and console marketplaces where people download content for games. Even if the content in the game is one way to start, of course, many video games begin with sort of teaser content, and then they have user downloads, which people will purchase for $5 or $10 later on as updates to the game. This is all distributed digitally. And so the idea that we would impose, and the difference I should add here is important for the purposes of this statute, which is how in the world would a vendor know if someone who downloads a video game from a website is, one, in the state of California, and two, is under the age of 18, right? All they see is a credit card number. And I checked the statute. Statute does not have an exception, as prior statutes have had, for example, for regulation of sexual content, that would say, all right, a vendor online gets off the hook if there's an order using a valid credit card, right? That at least would be quasi-reasonable, saying, all right, if they've got a credit card, then at least an adult may be involved, and this is probably not a child. No such requirement in this statute. And so again, not discussed very much by the parties, but I think a critical reason why this statute is being resisted so vociferously by the industry is that it would essentially put them on the hook for selling a video game to a minor when the video game manufacturer may be overseas, may be in any other of the 49 states of the Union, may not have the vaguest idea that the buyer is a minor, and has no way of proving that. So what do? Do you block all video game direct downloads that come from IP addresses in the state of California? That seems to me to be unfeasible, and that's something that the Supreme Court has taken into account in prior analyses, especially analysis that tried to restrict minors' access to sexual content on the web. The court there did become quite nervous about the fact that vendors across the country would be regulated by the state of California and wouldn't have the vaguest ability to discern whether or not they were selling to a minor. So I think that's another thing that bears sort of special emphasis in light of the actual goings-on of the video game industry. As to how the case is going to come out, who knows? People are really worried because every court to have considered this question has struck the statute down. So why would the Supreme Court grant cert if not to reverse? And there's some reason for that nervousness. Even the most recent appointees to the court, including Justice Kagan, have in their academic writings expressed some sympathy toward the view expressed by the state of California. That is, that the government, that a government with a pure heart can leverage those intentions into the ability to regulate free speech. That said, Kagan has also asked some very hard questions of the litigants in recent First Amendment cases, and so maybe this might come down the other way. But I think it's anybody's guess right now. I think the video game industry, which has a bigger budget than Hollywood and is a real American success story, is very nervous about this statute, and I think for very good reason. So we'll have to keep an eye on it.